Hello, this is Matt on the Moon Lambo channel. I got a quick legal update for you regarding the SEC versus Ripple case. And the SEC is seeking redactions of legal briefs they've filed, claiming that such redactions are necessary to protect their expert witness, Patrick Doody. Now, you may remember this guy because he has a hilarious last name. But even setting that aside, he claims to know the reasons that XRP holders purchased XRP in the first place, and he's put together, and I'll use air quotes here, an expert report. And this is kind of crucial because it plays into factors of the Howey test. So whatever he has to say, it's going to be impactful to one degree or another here. And I've made videos where I've talked about the claims of the SEC. They claim that there have been some sort of threats against him. We don't know the specifics. They haven't been cited. It's easy for me and everyone in our community, I think, to speak out against that. You should never threaten anybody for any reason. And, when it comes to something like this, my God, in particular, an expert witness in the SEC versus Ripple case, you're not helping if you're doing that. So it's easy to speak out against that type of stuff. Don't contact anybody in the case, frankly, whether it's a judge or anybody or an attorney, just don't do it. Now, that said, the SEC hasn't really provided sufficient evidence to prove the case that there is some sort of notable harm or threat towards Patrick Doody. So I'll just leave that part of the conversation as it is since I don't know. But regarding these redactions, now Ripple's claiming in a brief that was filed today, Ripple claims that the SEC's proposed redactions are actually covering up the SEC's poor legal argument and have nothing to do with protecting their expert witness. Plenty to talk about, but before we're going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to XRP community member and attorney James K. Filan, who shared these most recent legal filings. The first I'm going to share with you is from yesterday. It's what the SEC submitted. The second one is from today, and it's from Ripple. And I highlighted, as I typically do, the parts that I found to be most interesting so I can get to you the tastiest morsels in these documents here. It's going to be so good. Here is what Attorney Filan wrote. The SEC filed its request to seal its response to the Amici motion to participate in the Daubert Challenge. The SEC claims that while some information the SEC seeks to seal has already been publicized by Movement's counsel John Deaton, the SEC seeks to seal this and other material to prevent further threats to harassment of the SEC's expert. And so you see, as I dive into this thing, you may recall that regarding this expert report having to do with Patrick Doody, John Deaton, on behalf of the, whatever it is now, 68,000 XRP holders representing, wants to be able to file a response to this expert report, which he's not seen to this point. And so the SEC has an actual problem with that, because why would they want to hear what 68,000 or so XRP holders have to say about the expert report? Because I'll tell you what, Attorney Deaton, he's publicly stated this too. There are like thousands of XRP holders who are willing to publicly state why they purchased XRP, and I'm willing to bet that it's not going to be for the reasons that Patrick Doody says XRP holders were purchasing XRP in the first place. But anyway, the SEC wrote the following. Dear Judge Torres, pursuant to the court's June 9th, 2022 order, the SEC respectfully submits proposed redactions of its brief filed under seal on June 7th, 2022 in opposition to the motion by 6 XRP investors to file a brief regarding the opinions of one of the SEC's experts. So let's pause and note again what he's talking about there, the expert being Patrick Doody. And the motion in question would be what Attorney Deaton filed, because he'd like to be able to talk about this regarding this case. And then a little bit lower, the SEC wrote the following. The SEC submits that the proposed redactions to the opposition brief and sealing of 11 exhibits are narrowly tailored to serve the higher value of protecting witness safety in light of the likelihood that past harassment and threats will continue in the absence of such steps. And again, like I said as I was opening up this video here, of course, take it seriously. If it's really happening, take it seriously. The SEC's provided no evidence of that whatsoever. And Ripple says that the redactions, you'll see as we go further through the video, the redactions that the SEC are proposing here are not narrowly tailored. Let me go to the next page now. The SEC wrote the following. While some information the SEC seeks to seal has already been publicized by Movement's counsel John Deaton, the SEC seeks to seal this and other material to prevent further threats to and harassment of the SEC's expert. Introducing evidence and arguments about the effects of such harassment and threats into the public record could signal that such acts have accomplished their purpose, risking further future efforts to harass and threaten participants in this high-profile case, one that the press and public closely scrutinize. So just pause to think about what they're saying here. Gosh, I know the court, you're the judge, yet you'd like to have this, all the reasons, all of the evidence as to what's going on, and people reading this, they'd like to have that too, but we just don't want to share that information. We don't want to prove the point that we're making here. The public in particular shouldn't know about it. All these threats and stuff, all it's going to do is encourage them, so we should just, not be forthright and not share this information. I think it's ridiculous. You can protect an individual without hiding information from the public. And again, like if you're redacting the key information, like Ripple actually doesn't have a problem with that. They just have a problem with, requesting redactions that are not narrowly tailored. You'll see. Now check out this. An attorney, Jeremy Hogan, had something to say about this portion, so I'm going to read what he had to say in just a second here. But in this paragraph right here, I can't highlight it because it's just an image here. But if you look right about here where my mouse is moving, for those of you looking at the screen, it reads as follows. Exhibit F is a compilation of tweets prepared by SEC counsel, and the remaining exhibits reflect tweets and other public statements made by Deaton and other individuals about the expert. We recognize that this information, as well as information reflected in some of the proposed redactions in the opposition brief, is already on Twitter, YouTube, or other third-party websites. The SEC's sole purpose in seeking to seal this information is to avoid rebroadcasting it, consolidating and republishing threats and personally identifiable information on the public docket of a closely filed litigation affirms that these specific intimidation tactics against the SEC's expert were successful and provides a roadmap for further harassment and intimidation of the expert. So they're saying there's a bunch of stuff it's already been made public. It's widely available. We just don't want to mention it again here. We would like that redacted. That's what they're arguing. Now, here's what attorney Jeremy Hogan had to say. He wrote, Deaton may have commented on the SEC's expert witness. That is fair, desirable, and something that people should do, even if the commentary is negative. But the SEC's conflation of Deaton's comments with harassing/threatening statements others may have made is just ridiculous. So you see what they were getting at there. They said, the attorney Deaton, he did the bad stuff. He did the bad stuff. And by the way, the bad stuff that they're referencing was just attorney Deaton engaging in satire. I've talked about this ad nauseum, so I'm not going to get into it in this video. But he didn't do anything wrong. It's completely absurd assertions that they made here. And so then talking about that and then saying, hey, there's also threatening stuff against Patrick Doody. Pretty shameful, frankly, as far as I'm concerned. And then here you can see attorney Deaton on this entire topic wrote the following. As I tweeted before, since this involves a pending motion I filed, I won't comment. So he normally shares his perspective on all sorts of stuff, but if you're wondering why you're not getting that in this video, it's because he's not sharing it, which is perfectly reasonable because, again, it's about a motion that he filed. Now we get to what Ripple had to say about this, and this is a fun one, and it's not going to surprise you terribly much, I suspect. And this is the one from today, from Ripple's legal team. Reads as follows. Dear Judge Torres, we write on behalf of defendants Ripple Labs, Inc., Bradley Garlandhouse, and Christian Larson regarding the SEC submission of proposed redactions to their letter opposing Movement's motion to file an amicus brief regarding one of the SEC's experts. So, of course, again, that's Patrick Doody, of course. Then they write, the SEC's submission comes after the court denied the SEC's motion to seal the opposition letter and exhibits in their entirety and ordered the SEC to submit narrowly tailored redactions that are consistent with the presumption in favor of public access to judicial documents. So I'll just pause to note, and you may recall this, initially the SEC was just pushing for not just narrow redactions. They wanted the whole thing to just not be available, and the judge said no. So now they're all they can do is request narrow redactions, but according to Ripple, they're overstepping, and Ripple's attorneys wrote the following. Defendants believe that the SEC has not satisfied the standard for sealing documents in the Second Circuit, where there is a substantial presumption of public access for materials submitted in connection with non-dispositive motions. And then a little bit later they wrote, the SEC's proposed redactions sweep much broader, encompassing portions of their legal argument as well as documents already in the public domain. The SEC has requested redaction of passages that demonstrate the weakness of the expert's analysis. These passages do not appear to pose any safety risk, but instead appear to be targeting information that would reflect weaknesses in the SEC's case. So think about this. Who's not going to get the information? Well, we, the public, wouldn't get the information, right? And what are they hiding from us XRP holders? Because they know that we're going to respond. We're talking about this. It's a highly publicized case. They're hiding Patrick Doodie's whatever his nonsense is from his report, effectively. The arguments that Patrick Doodie makes, that's what they're redacting, according to Ripple. And we can't see that right now, obviously. But is that surprising? They don't want this out for different reasons. And I get this sense, I wonder if this whole thing about there being a harassment or threats, I wonder if those are just straight up lies. I can't help but wonder. If it is real, of course, take it seriously. But again, I cannot help but wonder because the SEC is full of a bunch of liars. So what am I supposed to do with this? Let me know what you think, though. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.